Yes, the stenographer has just signaled that I must wait. Thank you. Thank you, my lord. Well, I was still making or rounding up the point there, which is that in this case, and I'll demonstrate that now, as I said I would, the parties which bear the onus to establish the fourth element, which is the prospects of success, have not, in the case of Mr. Downer, not pleaded it. Forget about establishing it on any scale. But in the case of Ms. Maughan, it's mentioned, even that is just generous. It's mentioned in passing, and that's it. Now, for a party that bears such a heavy onus, if we are correct on the issue of the onus, then that should be the end of the case. It's elementary. Now, let me demonstrate why that is. Unfortunately, there's an unreported judgment which I was going to rely on, but one of the court staff has kindly offered to make an extra copy for me, so I'll hand it up when she returns. But let me tell you, well, we don't need a judgment, as I say, to establish the fact that the onus-bearing party must at least allege something. As far as Mr. Downer is concerned, I will challenge my learned friend, Mr. Badlander Senior, to tell us where in his founding affidavit they deal with prospects of success. And I'll give you a very quick answer: nowhere. So you can't just come as they do here. In the heads, they have a big heading called Prospects of Success on Appeal. But you can't do that. How can you have a heading about something that you have not pleaded and just say Prospects of Success on Appeal? What your duty is to raise that in your founding affidavit, and then that's what the onus means in its true sense. And I don't mean to insult the court, but because the last time the court said, well, we know this, I'm assuming that the court knows everything, but it's my duty as counsel, I just want to refer the court. I'm not, don't worry that is, in fact, my PA was over-enthusiastic and copied almost the whole chapter. I just wanted a few pages there. That's just a copy from Zephyr, which is the Bible on the law of evidence. And I'll just read the second paragraph. It says, since the incidence of the onus decides which party must fail on a given issue, if after the hearing all the evidence the court is left in doubt, Wigmore called it the risk of non-persuasion, and others have called it the persuasive burden. And then it says the onus shifts, but it is always on the primary party. I won't bore the court with the detail. It's a tight proposition. Now I'm telling this court as light meets day that there is no reference in the pleadings of Mr. Downer to this requirement. And just to assist my learned friend, in case he wants to rely on, he says at page 53, page 23, I'm sorry, of his papers, which is paragraph 53. Even though it's a bold allegation, but let me tell you, I'll tell you what's wrong with it. It says, I submit that given these findings of the full court and the findings I summarize paragraph 16, Mr. Zuma's application for leave to appeal has no prospects of success. This, however, will not deter him from bringing it, as this conduct too has been an element of his abuse of the court over the years. Well, firstly, even if that was about prospects of success on appeal, it wouldn't be sufficient because it's just a conclusion of law. But this is the wrong test. The test is not prospects of success in the leave to appeal. There's no such thing. The test is the one that they've correctly put in their heads, which is prospects of success on appeal. Right? And that test has not been pleaded and it has not been established. Of course, we know prospects of success and the leave to appeal is a different matter. It's a Section 17 point. And the Section 17 application has not yet been heard by this court. So even if that was the test, the court could not apply that test because it has not, that matter is not yet before it. So prospects of success on appeal have not been pleaded. Now let's go to Ms. Maughan. If you go to page 14. Yes. Yes. Yes.
If that is the test, then surely an appeal record ought to have been put before us for us to determine that.
No. No.
Okay, then can you just explain yourself?
Yes, I'll explain. Fortunately, if there's one thing we agree on with my learned friends, it's that point. The case in AfriForum said, and I think in Tlameza to some extent, said that yes, prospects of success is a factor and it must be established and so on and so on. However, in that court, in the appeal court, it said we don't have the record. And therefore, because we don't have the record, we will deal with the matter without dealing with that factor.
And they decided both in AfriForum and in Tlameza on the basis of an 18.3 application.
Because they did not have the record. Your point? Yeah, I'm coming to KNOP.
Right.
Actually, this whole case of today, it can be decided on KNOP alone. I'm coming to that. Right. Please. Yeah. I'm just addressing your question.
Okay.
Here, my learned friends, and I can't remember which one now. I think it's Mr. Badland. Concede, Mr. Badland Senior. So they concede that that principle that your ladyship is putting to me doesn't apply here, because there's the record in front of you. Because this is the same court that that dealt with the matter. So this court can't assume ask for a record, because it is the same court that is seized with the record. In Tlameza and AfriForum, those were appeals. Remember, my lady? Yeah. Those were 18.4 appeals. No, we're not there now. Yeah. So those cases with respect don't apply to this court. And as I say, it's considered anyway by the other side that that aspect of the case doesn't apply. I'll find it in their heads if they dispute it. But it's there in black and white. So this court, unfortunately, is seized with the question of prospects of success, and it's not pleaded. So let's then go to Ms. Maughan's. Please, let me find in their heads where they admit that the issue of the record doesn't. Ms. Maughan's pleadings, you'll find at page 14, paragraph 24.5. That's the high water mark of anything they say about prospects of success. They say the following further circumstances render this case to be more exceptional. If you start at page 13, then they give those things. And then the last one at 24.5 says the prospects of success on appeal, at least here they use the right test. The prospects of success on appeal by Mr. Zuma are so poor that his application and likely series of applications for leave to appeal can serve only as a dialectic tactic in his own criminal trial, and so on and so on. So they mention this in passing in the context of the so-called Stalingrad argument, not to convince this court that the prospects of success are in their favor. Nowhere in the founding affidavit will you find that suggestion. And in any event, again, even if they had mentioned it in the context that we are discussing as the fourth element, it wouldn't be sufficient for an Onus bearing party merely to just mention something and say nothing about it. So, now if we go to I beg leave to hand up this is a judgment of the Gauteng High Court, which this court has followed in another respect. This, and I apologize because I remembered this only when I was preparing now. You'll see at the end that I appeared in this matter in 2019 sometime. I think it was December 2019. Now, this is a matter of Bila, civil contractor versus Samanco. And this very point came up. And the court decided in our favor on appeal on the basis exactly that a court like yourselves, the court ACOR, had made a mistake by not recognizing the role of the prospects of success. Well, this was a judgment of Her Ladyship Justice Lukaimane. Ms. Lukaimane was an acting judge, and it was concurred to by Justice Bakwa and Justice Sadiwala that I mentioned earlier. This matter was very simple. You don't have to bother about the facts. It's a I don't know how many pages the judgment is, but it's quite short. And here, the other side, like here, had not dealt with prospects of success. And we explained to the court that that's a fatal omission, and therefore the matter must fail on that basis. And the court agreed with us. And if I take you very quickly to paragraph 23. So it is the applicant that was asked. It is the applicant's contention that in granting his order, Van der Vestes and J, that would be yourselves now, did not consider the prospects of success on appeal, and therefore on this ground alone the appeal must succeed. This court accepts that from the provisions of section 18, which we shall term the statutory provision, the common law requirement to consider the prospects of success on appeal remains. Therefore, a court granting an order in terms of section 18 should, as a matter of course, also satisfy itself as to the prospects of success on appeal. And then it goes on about how this was not done here. Let's just jump to paragraph 30, which was the owner's argument. They say the respondent, and that also goes to your ladyship's question in a way. The respondent argued that the prospects of success ceased to be a requirement with the enactment of section 18. This was after the court considered that the extent of the respondent dealing with prospects of success on appeal in his papers was, as indicated in paragraph 26 above. Again, it was the same here where it was mentioned in passing. Upon considering the views expressed by Binsward in quoted with approval in AfriForum, submission by the respondent cannot be correct. The correct position is that prospects of success remain a valid consideration in deciding whether or not to bring a judgment into operation in terms of section 86 of section 18. This is despite the fact that the issue of prospects of success is not specifically mentioned in section 18 itself, and that's the important thing. That's what we mean when we say it's a fourth wheel, if you like. And then says the appellant, on the other hand, submits that the respondent's application should have been summarily dismissed, which is what we're submitting here again, on the ground that the respondent, being the owner's bearing party, made no reference to the prospects of success on appeal in its founding papers. That's exactly what Mr. Downer has failed to do. No reference to the prospects of success on appeal in its founding papers. And as I say, in the case of Ms. Bond, a reference is made, but it's made in a different context and just in passing. And then 33, in the circumstances, I'm constrained to agree with the submissions by the appellant ourselves in the criticism of the finding of the court. It was imperative for the respondent in making out its case to raise the issue of prospects of success pertinently, right? And for the court to deal with that issue in definitive terms in judgment. Absent such a finding, the appeal must succeed. So what the full court then said was that absent a pleading of prospects of success and absent establishing it, then you cannot give a Section 18 order. It's quite simple. So that's exactly where we are now. But if you don't believe that, then you have to go to KNOP. Because that judgment was quite prophetic, if you like. But it will then be said, no, it's a judgment of another division, and so on and so on. Even though it states a very clear principle of law. As luck would have it, the SCA dealt with the issue of prospects of success in KNOP. And that deals with the question your ladyship asked. In KNOP, paragraph 49, the court said, in Justice Alliance, it was held that the court has a wide discretion to grant or refuse an execution order once the statutory requirements are satisfied, and that prospects of success in the appeal have a role to play in considering that exercise of that discretion. There is a dictum in AfriForum that supports this approach, but in both that case and Tlemeza, the record in the main appeal was not before this court, and the appeal said perforce to be decided without the full record or any consideration of the merits in the main application. Now, I've already demonstrated that that doesn't apply here, but you don't have to believe me. You must believe Mr. Which one is this? Mr. Jeff Butland, who says in his heads at paragraph 80, as I say, curiously, you look at the top of that page, then that's where all of a sudden the correct test is put, prospects of success on appeal, which is a different thing to what they've not pleaded in the. It's simply because we raised this in the answering affidavit as a point in limine. Now you can't do that. You can't raise a matter either in reply or in your heads simply because the non-onus bearing party has raised it as a point in limine. Anyway, this is what he says, Mr. Butlander, in his head. In the present case, the court does have the full record before it, and it is familiar with the record. There is therefore no obstacle to the court having regard to the prospects of success. So, as I say, I think it will be easier to believe Mr. Butlander's statement on that. All I can say is that I agree. So then, the question then, it begs the simple question. If this court must consider the prospects of success, on what basis must it do so when it has not been pleaded? The answer is on the authority of both the Bila judgment and KNOP. you'll see in paragraph 50 of NOP, it says, we have the full record in the main appeal before us and had read it in anticipation of dealing with the main appeal, but the argument on the urgent appeal did not include the debate over the prospects of success in the main appeal. So that, the GNUOP court, as it were, was in the same position as this court.
So I'm sorry, I was saying in the absence of a pleading, because we have the record, we can then consider the prospect of success.
No, I'm saying the exact opposite of that. I'm saying in response to the question as to whether this case is not like Temeza or AfriForum, in which case the court considered it without looking at prospects of success. I'm saying this court is exactly different. This case is like the GNUOP court, and this is like the court that the judgment that I've just handed up to you. So you cannot consider this matter without considering prospects of success, as Mr. Padlander says. Maybe it's easier if Mr. Padlander says it. In the present case, the court does have the full record before it, and it is familiar with that record. There is therefore no obstacle to the court having regard to the prospects of success. So Mr. Padlander says the exact opposite of what your leadership is putting to me. And I agree with him. Except that he can't then rely on the prospects of success, something that he has not pleaded. Okay, let's then put that aside and come to this. In this case, we have gone out of our way, not only in the absence of a pleading by an onus-bearing party, we, the non-onus-bearing party, have gone and we criticize here that 25% of our heads have to do with subsidiarity and so on. So we took it upon ourselves to show this court that there are prospects of success for Mr. Zuma. We had no duty to do so. We could have just kept quiet. Once they don't plead it, we have no duty to say anything about. That's what Zafet says. It's the duty of non-persuasion. In other words, if the onus-bearing party says nothing, that it must fail on that point. That's right. But having no duty, we went on to convince this court that the prospects of success are good on appeal. And we base that on three, and that's why this criticism is unfounded. Because we base that on three, well, there are many grounds that are pleaded in the notice of application for leave to appeal, but we don't have time to deal with all of them, so we'll just deal with three. The first one is that this court did not have jurisdiction. Now, if we have prospects of success on that point, that's the end of it, I'm afraid. As any court knows, jurisdiction is a gatekeeping requirement. So if it doesn't matter, you can have the best case in the whole world that the world has ever seen. But if the court doesn't have jurisdiction, you're out. Right? Now, it is in that context, and this point was going to be argued by Mr. Masuku, but I'll deal with it because I suspect we'll be pressured for time. The issue of so-called subsidiarity is raised in that context. We are not fools. It's Einstein who says the sign of madness is to do the same thing and expect different results. So we can't come to this court and want to convince you about the merits of the subsidiarity point, because you've already found against us, well, by saying nothing. But also, you are functus officio. There's nothing you can do about it. Even if that scenario that one of my learned friends painted where you say, oh no, here, we got it wrong. There's absolutely nothing you can do. You are functus. So all you can do is to refer it upstairs. So the purpose of raising the subsidiarity point is not to re-argue that point, please. It is simply to say this court's failure to deal with that crucial point, Section 14.2 point, call it whatever you like, whether you call it subsidiarity or the Section 14.2 point or whatever, we don't care about the labels. The principle is that when there is a statute and it governs something, a party cannot act against that statute without challenging the constitutionality of that statute. That's a simple, you can call it what you want to call it, but it's the principle of our law. And that's what His Lordship, Mr. Justice Wallace, was at pains to say. He did not use the word subsidiarity, but that's exactly what he was saying in Moyo. That why should you, if without attacking the constitutionality of the statute, use another forum and leave the constitutionally ordained forum to deal with the matter? That's all. So this court did, I mean, how can you say honestly, we raise a point of that magnitude and this court does not deal with it at all? At all. But there are prospects of success. Success on what? When this court did not deal with the issue. That's number one. Number two, this court made the cardinal mistake in that matter of relying on the South Gauteng High Court decision of Sutherland. Yes, okay, yes. I'll paraphrase because of time, because this is in our heads. Where's that section? Oh. Now, this court is page 19, I think. Yeah. Page 19 of our heads. Remember what Sutherland J said was, a court is a court. And in any event, these judges, they sit in the same court. So whether he's wearing a red robe or a black robe or whatever, it doesn't matter. This court, in finding against us on jurisdiction, relied on that dictum. Right? That dictum has been discredited by the same court. So how on earth can anyone say that there are prospects of success when you, with respect, my ladies and my lord, relied on a particular judgment, bona fide, because that was the judgment at the time. But that judgment has subsequently been shown to be wrong by the same court that issued it. But you must now say, no, we were right to rely on the wrong version of the judgment. Who does that? This court, with the greatest humility, should at least accept that it got it wrong on that aspect, or I don't even have to go that far. It must accept that it might have, or there's a reasonable possibility that the SCA will agree with the subsequent judgment of the Gauteng court, and not the one that was given on an urgent court in an interim judgment, but the one that is actually like this, which was part B, which was the actual setting aside. Now, the South Gauteng court in the subsequent judgment said that the approach that you followed is an oversimplification. And that was putting it mildly. It said the approach of Sutherland J was an oversimplification because it failed to take into account that a court sitting like you are sitting now here cannot have jurisdiction to hear a criminal matter. So at best, the only issue that remains, as we say in our heads, the only issue that remains is, and that will be answered in the SCA, is whether, even assuming the subsequent position of the South Gauteng High Court is correct, because that court was basically saying, if this matter could be classified as such, then we don't have jurisdiction. But I don't have to go through that. All I'm saying is that...
Sorry, I just want to make sure that you and I are on the same page.
Yes.
Is the submission that the South Gauteng court, which subsequently heard part B of the application, which served before Sutherland, disagreed with his finding in relation to jurisdiction.
Yes. No.
Okay.
No,
Please
that's not
clarify.
what I'm saying.
Okay,
No,
please
no,
clarify
no,
what you
no,
said.
no, my lady. Would be another oversimplification.
Okay. Please
No.
clarify.
I'm saying, okay, assume that there are two courts. One is in Gauteng, one is in Maritzburg. Okay? In the one in Gauteng, or in both courts, we raised the section 14.2 point.
Yes.
Right? This court decides to ignore it, doesn't deal with it. The court in Gauteng deals with it and says that the position that this court agrees with about a court is a court and what have you is an oversimplification of the point. In fact, I'm paraphrasing. It says that is an oversimplification of the point Mr. Zuma is raising. And they say, Mr. Zuma is saying that a court, the mere fact that we are in the same building is irrelevant because a court, a civil court and a criminal court are two different courts. And they even make an example. They say, for example, a judge sitting who's in the same division does not have jurisdiction to deal with an appeal when he's sitting alone. And therefore, jurisdiction in that sense is an issue. So I couldn't just wake up and go to a judge sitting alone and say, I'm doing an appeal from another judge. That court would say, I don't have jurisdiction. I will only have jurisdiction if I'm sitting with two other people. So that's why they were saying it's an oversimplification. But that's not, I'm not arguing the point here. That would be wasting your time. It will be argued in the SCA. All I'm saying is that the position that you followed has been subsequently found by the same court to be an oversimplification. I'm assuming, of course, because you didn't deal with the matter, I'm assuming that you thought the point was nonsensical.
But they agreed with Sutherland's findings on jurisdiction.
On the different issue, let me explain why.
No, I'm with you. I
Yes,
understand it.
you understand,
I just
okay.
want to make sure that you and I are on the same page.
Yeah, no, we're on the same page. That's why I'm saying, when I say, and what we say, when we say in our heads, my lady, the only remaining issue is whether this is a criminal matter or a civil matter. That will be debated by the parties whenever that. But you can read the second Gauteng judgment as follows. If we were to agree with Mr. Zuma that the matter falls under the what they call the warning of Wallace J.A. in Moyo, then he would win. You understand, my lady? Yeah. So they're saying, so the only reason they found against us on jurisdiction is because they didn't agree with us on the second leg. But on the first leg, they agreed with us and overturned Sutherland J, on whom you relied. That's the real crux of the point. All I'm saying is that with those facts, which court in this country can say, I relied on this position, it was departed from, I relied on it in January, thinking that's what the court said. That court then departs from it in March. But in April, I must say there are no prospects of success. What is that? That's almost like if the SCA had made a position which the SCA is entitled to, and then it changes its mind. It might say, no, we were wrong in that case. Then, of course, this court would be bona fide in having relied on the SCA judgment at that time. But once the SCA now later says, no, we were wrong, you can't then say, no, we're dogmatic, no, you were right. When the SCA says we were wrong, we say, no, SCA, you were right. You can't do that. Okay? So that's the crux of the point. So that's the first point. On jurisdiction, if we are right on jurisdiction, then that's the end of the case in our favor. So the prospects of success on that point are... I don't think there's an English word for it, because this court has not dealt with the matter. So there are two problems. One is the Mpahlele versus FNB problem. The second one is the point itself. The Mpahlele point is that a court of law is enjoined to decide a dispute. That's what courts are for. If a court fails to deal with a dispute or to give reasons, then the court has departed from its constitutional duty. And I think you'll find that either in Tlemeza or AfriForum, it's I think it's in Tlemeza. Paragraph, all I know is that it's paragraph 28. Okay, I'll ask my learned friend to look for the passage. But again, it puts a tight proposition that courts, this thing called the court, has no option if a dispute is raised but to decide it. One way or the other. You could have decided it against us, could have decided it for us. That's not the point. But you have no right to just not deal with it at all. And that was beautifully put, more beautifully put by Goldstone J in the Phahlele judgment, Phahlele versus FNB. And where there he says, I'm paraphrasing, that if a court fails to do that, it is breaching the Section 34 rights of the party that raised the point, because then it means their right under Section 34 to have the dispute adjudicated has been lost, and it's a violation of the rule of law, said the Constitutional Court. So that's the issue. Then the next issue is that this judgment, the judgment of this court, with the greatest respect, was based on what I will call three myths that were pleaded by the other side. Those three myths are the following, and I'll paraphrase for time. The first one is called the Stalingrad theory. Now, that is a myth because there is no such thing as the Stalingrad theory. It's a creation of the media. And the courts cannot just, there's another court case that says you can't just go around with media hype. To the extent that this thing called Stalingrad has received any judicial recognition, it was by Wallace J.A., and I'll explain why this court's approach is fundamentally opposed to that. The so-called Stalingrad theory has never been accepted by any court, in this case at least, in this country, except these three people here. Absolutely. And to the extent that you make history, then please allow the SCA to confirm. Pardon?
To say we're wrong.
Yes. No, to say you made history, even. So it's fine. But what you cannot do is to deny yourselves the chance to be confirmed to have made history. Well, in my respectful submission, you made history in the wrong way, because there's no court of law. His Lordship, Mr. Justice Kuhn, who have demonstrated, rejected the so-called Stalingrad thing in so many words. It was raised by Mr. Downer on the 11th, I remember that date as if it was yesterday, 11th of April 2022. Because I remember it because the following day was Mr. Zuma's birthday. We were standing here in this very court, and we said exactly what they are saying. We said, no, court, because we have an application for leave to appeal in the Constitutional Court against Kun J's judgment, please postpone this matter, and preferably postpone it sine die, because we don't know how long the thing will take. Mr. Downer, or whoever was representing the state, stood up and said, no, Justice Kuhn, you cannot allow that. This is Stalingrad and all sorts of things and what have you and what have you. And Justice Kuhn would have none of it. He said, I cannot deny Mr. Zuma's right for a postponement because of this. I'm granting it. Okay? They've raised it time and again, they even raised it before clearly J now in April. In April, Mr. Down, this time I know it was Mr. Down, because it's this April. This April, Mr. Down was standing where I'm standing. He said to Justice Clearly, when you postpone the removal application, please postpone it to a specific date so that the trial can start. Because this is Stalingrad. In other words, don't play into their hands and postpone it in an open-ended fashion. I stood up and I said, no, that cannot be, because there's no such thing as Stalingrad. This is just a phantom of the media. And the matter must be postponed. As to when the trial will start will be decided once the removal application has been done. And Justice clearly agreed with us. So it's the first time in the history of mankind that any court has given recognition to this nonsensical concept called Stalingrad. Mr. Badlander used the word nonsense twice. I'll try not to outdo him. But that was the so-called Stalingrad. This court bought into this Stalingrad thing wrongly. And again, I don't want you to say there's no Stalingrad. You've already put your colors on the mast that there is such a thing. All I want you to understand is that another court will make history in the correct way. So that's the first thing about Stalingrad. The second thing is that even if there was such a thing called Stalingrad, that thing is expressed by Mr. Justice Wallace J.A. in the following way. Moyo, I'll paraphrase again to save time. We're all familiar with Moyo. You remember that Justice, sorry, it's one of my favorite passages in Moyo, but I think it's 159. Anyway, he says the following. He says there's something called Stalingrad, and it manifests itself in the following way. An accused person who is well-mannered, like these accused persons, because they've come here to waste our time and money for no reason. An accused person who's well-mannered can do what is called preliminary litigation and come to court and raise all sorts of issues which should have been raised in the criminal court. And he says the term Stalingrad is sometimes used. So to the extent that Stalingrad ever got judicial recognition, it was when it is used by an accused person. Mr. Zuma, contrary, I know that it's it's difficult to unlearn this. But Mr. Zuma is not here as an accused person in this court. He's here as a prosecutor. And there has never been, Stalingrad has never been recognized even for an accused person, let alone this new one now of the Stalingrad of the prosecutor. I mean, I can't even fathom exactly what that means. But anyway, that's what this court has found. Some new Stalingrad based on prosecutorial delay. One cannot work your way around that. So, prospects of success on that point as well. That the SCA will say Stalingrad is what we said it is, not what you are saying. And they will rather side with Justice Wallace J.A. than this honorable court. Now, then the other point on which the prospects of success are good is stare decisis. And I won't waste time because that's been covered in a way. The Moyo and Tint say that you may not entertain so-called preliminary litigation. And this court did. And that's undeniable. But what is worse is that this court, in doing so, relied on Solomon, Netco, Nandandal, Gilishana, Netco and Gilishana is the same case, and I think Phillips versus Fenton. Well, I've got news for this court. And I'm saying this boldly, again, you made history. There is no other court in this country. I'm putting aside now the subsequent decision in Gauteng, which is also being appealed. But at least by the time you gave your judgment, there was no court in the history of South Africa ever that found that a court sitting as a civil court has jurisdiction to deal with title to prosecute or anything to do with it. Never. It has never been done. All the cases they rely on actually are against them, starting with Solomon. Solomon says the following. Solomon says, and I think it's against the letter 616, if someone has got the judgment. Solomon says, no, these issues must be referred to the trial, to the criminal trial. Dzilichana, there were 5 points raised there. That's net conversation Dzilichana. The first 3 points dealt with title to prosecute. The court said, no, we refuse. We can't deal with this. It must go to the criminal court. And, sorry. Oh, thank you. Yes. Oh, to come to that. Oh, yes. The Mpahlele judgment that I refer to is on page 10 of our...
It's paragraph 12.
Yes, page 10 of our heads. Oh, okay, I'm sorry. Okay, it's paragraph 12 of that judgment. It's longish. I think the court is probably familiar with it, for all the duties of judges to give reasons or to deal with the matter. Thank you, Mr. Musu. Now, I'm saying that in all those cases, the courts found that the matter of title to prosecute must be referred to the criminal court. So, this myth that those courts are supportive of them is wrong. Let me explain what was said in Solomon. In Solomon, it was said that if an accused person says that the only reason that I'm being prosecuted is the pursuance of an ulterior motive, then the court, of course, will have jurisdiction to entertain that. And that makes sense. Why does it make sense? Because you remember that subsequently in the Zuma case, and in Radel, which again this court also, with respect, misrepresented. In both of those cases, it was said that if you only raise ulterior purpose, you can't succeed. Because it's irrelevant if you have an ulterior purpose. So let's assume Mr. Zuma had a purpose of Stalingrad. But if, coupled with that, he also has an intention to secure a conviction, then the ulterior motive is irrelevant. That's what our courts have said. Harams in the Zuma case and Majid in Radel. Paragraph 68 of Radel, which I read out to this court, by the way, the last time, says, like Zuma, the other cases relied on by the applicants must be distinguished from the present one. As stated, the unlawful arrest and malicious prosecution cases rest on a different substance. And here's the catch. It says, bad motive in and of itself can never be an adequate ground for escaping arrest or prostitution or prosecution. Never. That's what it says. So that's the law. So, and it's correct what Solomon says. But this is not the case before you. Here, you are bound, I'm afraid, by Plascon Evans. Because when a respondent says, I have a motive to secure a conviction, you can't cross-examine the piece of paper in front of you and find that he's lying. That's why these things should happen in the criminal court. you can't simply say, well, Mr. Zuma says he seeks a conviction, but we don't believe him. Because this court is not geared for that. Nobody, he has not been cross-examined. Plascon Evans says you must believe him. Unless if the other side, we all know Plascon Evans. So that's the predicament that this court has faced. So that's the third predicament. So we say, even though we don't have a duty, just on those three alone, forget about all the other things about the interdict that was granted without anyone pleading even one element of interdict. Forget about that. Just concentrate on those three. So that's the context. Now, if you are with us then on the well, you don't even have to be with us actually. You may be even against us on everything I've just said now. But the point remains that they have not discharged their duty. We have discharged a duty that we don't have to show that the prospects of success are good on Mr. Zuma's point. So let me then move to the three elements. Assume then that you find, for some miraculous reason, that there's agency. Section 18.4 doesn't matter. The fact that the appearance on the 4th is unpreventable doesn't matter. You find that the fact that they did not plead prospects of success doesn't matter. And you find that, nevertheless, the fact that the judgment you relied on jurisdiction was discredited by the very same court doesn't matter. And you find that the brand of Stalingrad that was invented here by my learned friends, which is prosecutorial Stalingrad, let's call it that, is actually what the law is. And every court in this country will agree with that. Assuming on all those things you are right, then you still have to deal with the three requirements. Exceptional circumstances does not mean that this is a case that is, one of my learned friends said they have not come across it. Well, that's his problem. There are cases. There was even a case, if you remember, I think it's called Van Deventer, where an accused person wanted to privately prosecute a judge because the judge had found against him. So the mere fact that my learned friends might not have come across those cases doesn't mean that they have not happened. But let's then go to the gist of what was said in Kluop. Remember, and let's assume all this Stalingrad and what have you is actually had any water. This is what, so if you want to decide this case, you must just think one thing, Wallace J.A. Because Wallace J.A. dealt with that issue again in Knoop. He says in paragraph 47, assume when he says dishonest, think Stalingrad. He says, one can readily imagine that an order for the removal of a dishonest BRP, you remember this was a case about the Guptas wanting to remove BRPs, will provide grounds for the court to order that the immediate and irreparable harm being suffered while waiting for the enrollment, hearing and outcome of the appeal to be the foundation of an execution order. I'm sorry, that the removal order should have immediate operative effect, but unless, this is the important part, but unless there is a real and substantial risk of immediate and irreparable harm being suffered while waiting for the enrollment, hearing and outcome of the appeal, the foundation for an execution order will be absent. Let's decode that. So he's saying, even in the unlikely event that you find that there are exceptional circumstances, even if in the event that you find that there was dishonesty, unless the other side can show that there'll be immediate and irreparable harm being suffered while waiting for the enrollment, hearing and outcome of the appeal, the foundation for an execution order will be absent. It can be put clearer than that by the SCA. So forget about Stalingrad, forget about all these things, assume that they are there. But that can never relieve the burden. Now, immediate, what is the immediate irreparable harm? Comes back to this issue of the 4th of next week. Well, at the risk of stating the obvious, there must be what you call causality. If you read 18.3 properly, the irreparable harm must be causally linked to the relief that is sought. I mean, that's again really stating the obvious. So you can't just say, I'll have irreparable harm when I cross the street, but give me relief about the sea. There must be a connection between the two. Now, if the 4th of August, whether we like it or not, is going to happen, and the accused persons must be there to, even if it is to tell the court what happened, then how can it be, what harm would you be preventing by granting the order? Because the alleged harm is going to happen anyway, whatever you do. So how on earth can they establish any irreparable harm linked to the order that they seek from you? If whether you give this order, that harm will eventuate. Whether you give that order, that harm will eventuate. That should be plainly obvious. And that goes back to the question raised by the presiding judge on 18.4. And the Knoop case. And thank God for Justice Wallace J.A. Because before this, I can tell you, as a person who's practiced this area of law, before this, the respondents used to say, no. Remember that AfriForum said you must prevent the toing and froing and what have you. And therefore, you can give an order that is, prospective or prophetic, that covers even future appeals. In other words, you could say, according to that false logic, you could say, we're granting you the order, but we're also saying that even if you appeal to the SCA, that order will be operative. In other words, you don't have to come on the 4th. Well, Knoop has shown that that is palpable nonsense. And that's my quota of using that word. Knoop says that you can't, how can a court do that? And this goes back to the whole subsidiarity point, or whatever you call it. Justice Wallace says if you did that, the court would then be making a finding that second guesses the statute. And that cannot be done. So you can't, as a court here, undo the automatic suspension, or rather the suspension that comes in as a result of the automatic appeal. And this is what he says at paragraph 20 of Knoop. At paragraph 19, he quotes section 18.4 as it is, and puts in emphasis the last part, section 18.4 Roman 4, which says such an order will be automatically suspended pending the outcome of such appeal. In other words, pending the outcome of the automatic appeal, the order will be suspended. In other words, will be back to the 6th of June. Right? Then he says, the section provides a safeguard against irreparable prejudice being occasioned as a result of a court granting an execution order when it should not have done so. In other words, if this court gets it wrong. The court must record its reasons immediately, and the aggrieved party has an automatic right of appeal, unlike the ordinary situation where it is necessary to obtain leave to appeal, what Mr. Stephen Buckman said correctly. An appeal against an execution order is one of right, and the party that obtained the execution order cannot object to it. If they wish to sustain the execution order, they must oppose the appeal. If they wish to avoid being prejudiced by the execution order being suspended, their remedy is to approach the head of the court to which the appeal lies, not the president of the SCA, and take all steps within their power to secure a hearing of the extremely urgent appeal for which the section provides. As noted above, Mrs. Gupta's attorneys did nothing of the sort. And then it says, I'm jumping paragraph 21, 22. The provisions of section 1844 are clear and emphatic. An execution order is suspended pending an urgent appeal by the aggrieved party. The suspension of the original order in terms of 18.1 of the Superior Courts Act continues until the disposal of the urgent appeal. It can never be clearer than that. The suspension that was there when we filed the application for leave to appeal continues until the disposal of the automatic appeal by the SCA. And now, as the appeal hearing was looming, purported to terminate the business rescue and so on. And then at 25, which is what you are asked to do, they spell it, they say the suspension order was explicitly directed at overriding the provisions of 1844 and whatever the name of the company, took advantage of it in the respects set out above. And then Wallace J.A. summarizes the position at paragraph 27. It says, 1, no such order was asked for. Okay, here it's asked for, so let's jump that. B says, the order flew directly in the face of the statute that explicitly says that pending an urgent appeal under section 18.4, the operation of an execution order is suspended. And it says, Ntlhameza did not only provide any authority in favor of the grant of such an order, but was authority against it, something we had been arguing ad nauseum in the lower courts and which was not understood. That Ntlhameza was not authorizing any such thing as preempting 18.4. But fortunately, the SCA now put a lead on that. And here's the last part, D. Remember what they are saying when they rely on Solomon. This is the danger of relying on a case of 1950 in 2023. They say that this court has got inherent jurisdiction, as was said by Roper J. in Solomon. But this is what the SCA said. The inherent power of a court to regulate its own procedure cannot be used to override the provisions of a statute directly governing the issue. So that also brings back the what we call the subsidiarity point. So this court cannot use the so-called inherent power to entertain a criminal matter simply because it has inherent power. Maybe in the 50s it did have, but now we have a constitution. And the constitution binds everyone. It says in section 39.2, I think it was Mr. Badlander Sr., says the Criminal Procedure Act cannot be reconciled with the Constitution because it was passed in 1977. I have never ever had a submission that is poorly made. Our courts have said that all the statutes that were passed under apartheid, of course, were passed without a constitution. But once the constitution came, and that statute is assumed to pass constitutional muster unless it has been challenged. So the fact that the Criminal Procedure Act was passed in 1977 or 1901 is irrelevant. If you want to attack it on that basis, you must attack its constitutionality. That's what Wallace J. said. And in any event, if you don't believe me or Wallace J.A., you must believe the drafters of the Constitution. Because they said in section 39.2, when interpreting any legislation and when developing the common law which could have come before Christ, or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. What that means is that any statute that is being interpreted, doesn't matter when it was enacted, even the common law itself must now be looked at, as I think one court put it colorfully, through the prism of the Constitution. Now, so KNOB is total authority now, indisputable. You would have to say, if you grant this order, that the SCA was wrong in Knob, and that the SCA will this time entertain the order that Wallace J.A. said cannot be issued. How can you say that? You can only say that if the stare decisis rule is not being observed by this court, because you'll then be saying a higher court superior binding on you was wrong, and you issue the exact order that the SCA said should not have been issued in favor of Mrs. Gupta, and you will go ahead and issue it nevertheless. Well, I can tell you, even if the test was what Mr. Badlander was saying about prospects of success on leave to appeal, or prospects of success in the appeal, the automatic appeal, it's guaranteed that the SCA is not going to agree with such an order. Again, basically. It will simply say, that court should have just read our judgment in Gno. Now, so that's the issue of that kills two birds with one stone. It's the irreparable harm, but also the issue of what I call stare decisis, which links back to jurisdiction and prospects of success. Again, all that this court has to accept is that the SCA has pronounced on this, and that is the position. So I just want to see that I'm not leaving anything else in Knoop, yes. So that's the position. As far as the authority of the Gauteng court is concerned, that I handed up, that court is very clear that you don't have to, which is what happened to us. It said you don't have to entertain the three requirements if you have not pleaded or established prospects of success, because it is now the fourth requirement. If I may just right now okay, let me take one step back, because again this is a point that is often misunderstood. Why does the court talk about the so-called heavy onus? Or it is because of this. Remember where this whole thing comes from. It comes from the common law, as explained in all the three SCA cases. The common law used to say, we all grew up on that, it was encapsulated in Rule 4911. Rule 4911 used to say in the 90s or before 2010 that a judgment is automatically suspended unless the court that gave it finds that it should be operational. South Cape. That was encapsulated in South Cape. What the introduction of Section 18 has done, intendedly, was to heighten that test. In other words, Section 18 is by definition a section that is intended to protect the losing party. Let me repeat that. Section 18 is by its nature a heightened protection of the losing party, because the legislature felt that the protection of the losing party that was there under the common law is not sufficient. Right? How did they do that? They said, no, let's find a way of heightening this thing. Firstly, in 18.1, we will say that there must be exceptional circumstances. That was heightening the test. But they said, no, it's not enough. And they came to 18.3 and said, let's heighten the test even higher now by saying that the irreparable harm, the party that wants to execute must show irreparable harm to itself and no irreparable harm to the other side. Now that's For me, that's actually the more revolutionary change, more than whatever is in Section 18.1. Why? Because we all know, as I say, those of us who practice in the 80s or 90s or whatever, that what used to happen then was what was called a weighing process. So you would say, my irreparable harm is better than yours, and the court has to weigh. And the introduction of Section 18 has banished that weighing exercise. It says, no, you no longer have to weigh. They must show that there's no irreparable harm. And even if they do, or rather, they must show that there's irreparable harm to themselves. And even if they do, they must now show that there's no, zero. Not one that is less, there must be no irreparable harm to the other side. So the test has been heightened deliberately 3 times over. As if that is not enough, the court then put, or rather, the legislature put 18.4 as another protection. It says, you'll have an automatic appeal if it's found against you. And then it put another protection and said, if, while that appeal is happening, the order will be suspended. So, if you conceptualize an onus as a hurdle, you must say the hurdle was here, and the court put it here, and here, and here, and here. That is why the SCA says it's a heavy onus, not just a normal onus. So that's what the legislature wanted to do. There's no court that can then second guess the legislature and say, no, we must protect the winning party, you know, irrespective of what the legislative intent is. Because the legislative intent is clearly to say your Section 34 rights, your right to appeal, would be meaningless if the order, if you just lose, there's a car, and then they say this one, the car belongs to this one, and then you lose, the car stays there. And while there's an appeal, well, the car is probably even a better thing because it's not consumable. Let's say it was something consumable. Then by the time you win, quote unquote, your so-called appeal, the thing is gone, it's dissipated. Or the car has been ravished and by the other side. This section is meant to protect you as the losing party to say, while all that is happening, let us preserve the status quo ante. Those are the words used by the SCA. And it says that judgment is a nullity. Right? And they want to rely, what I call lifting yourself by your own bootstraps. To win in this case, they want to rely on the very judgment that is a nullity. They say, no, but you remember you found that it was abuse. Remember you found Stalingrad. Remember you found this. But that's like, I don't know what, it's a Twitter's argument. Because that's the very thing that is being appealed against, from which we need to be protected. So you can't lift yourself by the same judgment that is now under appeal and use it as the logic to say you must be granted the relief. So in all, in rounding up the following, we say the following. A, the matter is clearly not urgent because it's the 4th of August is unpreventable. And one of the reasons why it's unpreventable, my ladies and my lord, is I can't remember what Mr. Stephen Badlander said about this, but it was another dismissive suggestion that there's no harm that will be suffered by Mr. Zuma. Well, nothing could be further from the truth. Section 11 of the Criminal Procedure Act makes it very clear that if Mr. Zuma does not pitch on the 4th, the case will be dismissed. All right? So this is not a normal situation where as in the civil court, if the party doesn't come, the court might postpone its sine die or whatever, or give a default judgment or whatever. Section 11 says, if the private prosecutor does not appear on the day set down for the appearance of an accused, that's the 4th of August, in the magistrate court or the trial for the accused, the charge against the accused shall be dismissed unless the court has reason to believe that the private prosecutor was prevented from being present by circumstances beyond his control, in which event the court may adjourn the case for a later date. So, one of the, I think it's Ms. Maughan, who says, no, we're not saying, we're saying that there'll be no need for an appearance on the 4th. Well, I can tell you now, if Mr. Zuma made that mistake, foolish mistake, then that will be the end of this whole matter. So there is distinct harm. So what they're asking for, remember, they're not saying he must just come on his own, which would be bizarre anyway. If they wanted that relief, then they must ask for it. They must do an interdict. That's what happened in the Gauteng case. In the Gauteng case, by the way, there was an interdict, the Sutherland, you are familiar with it. The Sutherland interdict was meant exactly for that, to say, okay, we cannot stop the private prosecution itself, but we want to stop the appearance of Mr. Ramaphosa. What has happened in that case is that that case still sits in the criminal court to avoid the Section 11 effect. It's actually postponed to the 29th of August now. So it will sit on the 29th of August in the absence of Mr. Ramaphosa. Why? Because he obtained an interdict specifically about his appearance. But he could never have obtained an interdict that binds the criminal court not to sit, because that would have been fatal to Mr. Zuma's private prosecution. So I don't think this point was well understood, but that's what it means. It simply means that the 4th, it reinforces the point that the 4th of August cannot be avoided. Quite apart from the fact that you would be usurping. Imagine if we arrive in that court and there's Judge X, and he says, yes, Mr. Mpofu, and I say, well, there's nothing I can do because the full court just found that its judgment survives no matter what. That judge would say, but what are you talking about? You were supposed to come here and say, my Lord, which is probably what I'll do next Friday. My Lord, there is a judgment. It is being appealed. That appeal, we don't know how long it will take. And therefore, the matter either must be postponed as matters get postponed on some estimation that the appeal might be disposed in 2 or 3 months' time, and get a date. Or we might even say, postpone the matter sine die, because as Mr. Badlander Stephen said, we don't know how long it will take. And that cannot be confused with the situation of what happened on the 2nd of February. On the 2nd of February, there was no judgment of this court. And that is why the position of a postponement sine die was rejected. But there is authority from the SCA that there is no complete bar to a postponement sine die. You'll find that in this book, Tutoy, Volume 1 at 22-100. It's a commentary on Section 168 of the CPA. And it says, you know that 168 says, a court before which criminal proceedings are pending, that's the court on the 4th, may from time to time during such proceedings, if the court deems it necessary or expedient, adjourn the proceeding to any date on the terms which to the court may seem proper and which are not inconsistent with any provisions of this Act. So the court next week can apply Section 168 and either postpone the matter to any date, as it is said here, or sine die. It was believed until the SCA clarified the matter that a criminal matter by definition cannot be postponed sine die. But this is what the commentary says. The court found that there was authority to the effect that a criminal appeal could be postponed sine die, and it's S versus Mazongolo. I won't read out the thing. And then the other one is Brosi versus Brosi, which is 2012 Zaska 151, unreported SCA case 602/2011, and so on. So all these are things that can happen next week, where there can be a long postponement or one sine die. But this court must say no. We are precluding that court next week from looking at the the realities on the ground, so as we say in the language. And that court, we assume that that court will not have the capacity to manage the case and say, okay, there's an appeal, so we either give a long postponement or we give the postponements to the day. Why would this court do that? And then finally, Mr. Badlander Sr. says that in his elucidation of what he says the court, this case is not about, that he says we misunderstand their case because we introduced the issue of the criminal prosecution. No, I want to challenge this court. Go and read Mr. Badlander's founding affidavit. And I won't put my head on the block, but 80% or more of that is all about the criminal prosecution where Mr. Downer is prosecuting Mr. Zuma. And when we respond to the case that's presented to us, they say, you've misunderstood. You must talk about the private prosecution. But how can you talk about the private prosecution when they have put 10 pages about Stalingrad, not in the private prosecution, but in the public prosecution? So conceptually, this court must understand three things, or distinguish three things. There are three cases here, and all of them have a life of their own. There is this case here in the civil court. There is the criminal prosecution court before a judge whose name we don't know next week. And then there's the criminal prosecution of Mr. Zuma, which is a subject matter of the removal application, which will happen on the 15th of August. There are three distinct cases, and they must never be confused. So when we say you will be preempting what happens in the criminal court, we don't necessarily mean the Clearly court. We're saying that will happen as well. But we're saying you will certainly be preempting what's going to happen to the other court, the second court that's sitting next week. But you'll also be preempting, because my learned friends both say, well, she's going to have to appear forever and ever, or we will appear before a prosecutor who is prosecuting us, unless clearly J finds in our favor. Now, that's not just a small qualification, as they are making it out to be. It's a serious one. So you must prevent something which might never happen, because clearly J may in any event find that Mr. Downer should not be the prosecutor. And that goes to the myth of all these myths, which is Mr. Downer's irreplaceability or indispensability. This court bought into that, but it doesn't mean other people are going to buy into it. Because this whole theory is based on the silly notion that Mr. Downer is the only person who can prosecute Mr. Zuma. Once you remove that, the whole house of cards falls. Because then the connection between this case and the private prosecution and the matter before J falls away. Because the one has nothing to do with each other. You can find something here and Mr. Downer can be replaced as a prosecutor, as counsel gets replaced all the time. And then there'll be no crisis. So it's a self-serving, self-created crisis based on the myth of Mr. Downer's irreplaceability and indispensability. That's why we ask the question rhetorically. What would happen if Mr. Downer, God forbid, was hit by the proverbial bus? Does that mean Mr. Zuma's prosecution will fall away? Oh, no. In a country like ours, I shouldn't even make that example. But it is to drive the point home that Mr. Downer is not irreplaceable, and that to the extent that his case is based on that flimsy ground, forget the other flimsy ground called Stalingrad, forget all the other reliance on Sutherland and all that, it falls away completely. Oh yes, Mr. Downer. Let me not blame Mr. Jeff Badlander, although he might have had something to do with this. says at page 10 of their founding affidavit, paragraph 24. Now there's some backtracking, which we welcome, by the way. He says, the purpose of this application is to allow the criminal trial to commence. So if you understand the distinction I was making, that criminal trial means the criminal trial before Trilogy, not the one of next week. Notwithstanding any appeal Mr. Zuma may launch against the judgment of the full court, because such an appeal will itself constitute a further abuse of process driven by Mr. Zuma's ulterior purpose to delay the commencement of his criminal trial against the Trilogy trial, in which I am a prosecutor. This should not be countenanced by this court. So the purpose of the application is made clear, that it's about the criminal prosecution before Trilogy. When we then respond to this, we're told, no, but why are you bringing that criminal prosecution before Trilogy? Because it has nothing to do with this case. But we're responding to what they told us was the purpose of their application. What else can we respond to? So the bigger point really is this: that if we really compartmentalize these cases into their proper, so that we don't fall into this trap of, for example, applying Stalingrad when Mr. Zuma is a prosecutor, because we now have in our mind that he's an accused, because he's not an accused before this court. Then it will be understood that this court, in granting this order, will not only be defying the statute, but it will also be undermining both the criminal courts that are going to sit in August on the 4th and the 15th. Now, if I can just check my notes, my lord. There's 6, yeah, that's more than enough. Yes, my learned friend says I should mention the issue of the Hofmeyr affidavit, but I'll just do it in one sentence, which is just to emphasize the point I was making. Again, we don't, and even if you took the criticism that we should have said this paragraph, that paragraph, but it's thick. That criticism is thick, coming from people who have attached in these papers the judgment of this court, all 68 pages of it, as if this court doesn't know what it said. But let's put that aside. The point we're making by referring to those is that this court also got it wrong on even on the facts. There are such glaring misdirections of fact. There's a backtracking today by Mr. Jeff Badlander on the issue of the so-called 20-year delay. And that's because this court found that Mr. Zuma was responsible for a 20-year delay, which is untrue and is now been considered, but in a slight of hand kind of manner. Mr. Zuma was not responsible for any 20-year delay. It's a lie that we pointed out before. The so-called 20-year delay starts in 2003, for example, and Mr. Zuma was only charged in 2005. So already the 20 years is gone. But the so-called 20-year delay includes a 9-year period between the 6th of April, I think it was, in 2009, when the charges were withdrawn, and when they were reinstated in 2017, 17 or 18, yes, right? Now, uncannily, that period actually was really 9 years. And so this 20-year thing is just a myth, my ladies and my lords. The fact that this court bought into it is fine. We will deal with it later. But it's a myth. It does not exist. It also includes the Section 106 litigation, which Justice Kuhn never said was Stalingrad. In fact, he said the opposite, as I indicated earlier. So it's just smokes and mirrors which were meant to pull the proverbial wool over this court's eyes. It succeeded, that's fine, but it cannot be taken seriously. The SCA is never going to agree with this court that Mr. Zuma was responsible for a so-called 20-year delay. As we say in our heads, all you need for that is to be able to count. A 5-year-old child will have to count. You say, okay, 20 years, 2003 to 2023. Yes, it's 20 years. Minus 2, 18. Minus 9, it's 7. Minus, that's all. And you'll see that the so-called 20-year delay theory is based on carefully. It even includes a period where the public protector made a finding, apparently, and it includes a period where the DA brought the spy tapes case. That was Mr. Zuma's fault. It was part of the so-called 20-year delay. Yeah. So this case, the so-called case, is built on really, to call it myths is being generous, is built on deliberate distortions of the facts, of the objective facts. As I say, this one is an arithmetic fact, the 20-year delay. One doesn't need a law degree to just say this. There is no such thing as the 20-year delay rule, or the Stalingrad theory, or the irreplaceability of Mr. Downer. Those are if once you remove those 3 legs of that table, it's no longer a table. It will just it will fall away. I don't think there's any need to even address the question of costs, because I mean, this is obvious. There's an automatic appeal. Whatever costs will be costs in that appeal, if we get to that. But our submission is that one does not even have to go there. One has to find costs against these parties who come here on an urgent basis and say to 3 judges who could have been busy doing other work, they must come and give an order that is not going to make any difference to anybody at all.
Thank you, Mr.
That's the issue that requires judicial censure and judicial opprobrium in a ideal world.
Thank you.
Thank you, my Lord. My Lord, I'm going to deal with 5 matters. I'll be less than 15 minutes, I hope, because my learned friend for Ms. Maughan is going to deal with some matters which otherwise I would have to duplicate. So the first issue is that our learned friend says that there's an onus on Mr. Downer to prove that there are no prospects of success. There's an onus on him to allege it and prove it, and so the application must fail. Well, with due respect, that is exactly wrong. There's an onus created by the statute to prove the 3 statutory requirements. Exceptional circumstances, irreparable harm to the applicant, and no irreparable harm to the respondent. The statute says in section 18 that burden falls on the applicant for for this relief to prove those three statutory requirements. There is no onus, none, to allege and prove that there are no prospects of success. The prospects of success are simply a matter which the court may consider in its exercise of its discretion. There's no onus in that regard. It doesn't have to be alleged as a fact and proved as a fact. And that appears from the judgment of His Lordship Mr. Justice Wallace in the Knuf case, which my learned friend is so attracted to. This is what Justice Wallace said in paragraph 45. He said, he referred to the requirements of section 18, in particular section 18.1 and 18.2 and 18.3. He said, these provisions have now been considered by this court in 3 judgments. The effect of these is that an applicant for an execution order must prove 3 things, namely, exceptional circumstances, that they will suffer irreparable harm if the order is not made, and that the party against whom the order is sought will not suffer irreparable harm if the order is made. Those are the 3 matters on which there is an onus. There is a 4th matter which may be relevant, and the court dealt with this as follows in paragraph 50, I beg your pardon. Our finding that the 3 requirements for making an execution order were not established means that we didn't have to consider whether there's a discretion once they are present, and if so, whether the prospects of success should affect its exercise. So the court says there are 3 matters on which there is an onus, and then if that onus is proved, if that onus is discharged, there may or may not be, prospects may or may not be relevant to the exercise of discretion. So it's absolutely wrong to say that there is an onus to prove absence of prospects of success. The Supreme Court of Appeal made that quite clear. There's an onus only in respect of the 3 statutory requirements. And it doesn't help with due respect to rely on the Bila judgment in the Gauteng High Court, because that was given before the judgment in Knop. Knop means that Bila is wrong. There is no such onus. And that's really the end of that matter. So it's not. I don't have to repeat myself. Won't be necessary. I will say that Mr. Downer makes plain in his founding papers what his attitude is to the prospects of success. He says in paragraph 59 of his founding affidavit. Paragraph 59, he says, no, I can't find it. But he refers to the absence of prospects of success. It's true in the leave to appeal. And then he says in paragraph 91, he refers to what he calls the unlikely event that the full court's judgment or his appeals, leave to appeal or his appeals will be successful. And so he makes his attitude clear on that, but he doesn't have to plead it, and he doesn't have to allege it, because there's no onus in that regard. The question is, it can't really be a question of onus because it's a question of law. It's a question of law what the prospects of success are. You can't make affidavits putting up new facts as to what the prospects of success are. The facts are before the court, and the court then looks at those facts and decides on the law what the prospects of success are. But the judgment in the Knuf case is clear. There is no onus in respect of prospects of success. The onus is in respect of the statutory requirements. Then the second issue I want to address is subsidiarity. Again, the complaint is made that the court didn't refer to subsidiarity in its judgment. I made the point already that the court dealt with the issue of should this be done in criminal or civil courts. You dealt with this fully in paragraphs 74 to 78 and in paragraph 100 of your judgment. You referred to 6 cases: Solomon, Van Deventer, Phillips, Hudson, Western Assurance, and Nedbank versus China. you cited 6 authorities, all to show that these proceedings can be brought and have to be brought in an application. All you didn't do is give this the label of subsidiarity. And we say, if the court did somehow err in not putting that label to it, and I've shown the court why it's the same issue, subsidiarity is exactly the same issue. If the court did somehow err, all that follows is that a court might be inclined to grant leave to appeal on that ground, failure to to refer to subsidiarity. We say a court shouldn't do that, but if a court did that, that wouldn't affect the prospects of success on appeal, because the prospects of success on appeal would be, well now, does subsidiarity apply? And the short answer will be no. It has finds no application at all. So although the court should have mentioned it and didn't mention it, it doesn't bear on the question of prospects of success, or the merits of the appeal, because there's nothing in the point. A learned friend made a long point that the court, that Solomon and others didn't deal with title to prosecute. Well, of course not. The court said that that's not a matter for themselves, that's a matter for the criminal court. That's been our case all along. We've never said that this court should deal with title to prosecute. We never asked you to deal with title to prosecute, and you didn't deal with title to prosecute. You dealt with abuse of process, which is what all of these courts have said is a matter for this court. And that's a matter. It's a matter for this. Where an abuse is alleged, you go to motion court and you ask for the process for the abuse to be stopped. That's what we asked you to do, and that's what you did. You didn't ever say. We didn't ever ask for a decision on title to prosecute, and we didn't get one. Then thirdly, the third one is a brief point. The learned friend says Stalingrad is a phantom created by the media. I'm afraid that's not true. It's a phantom created by Mr. Zuma's senior counsel, who announced that that was going to be his strategy, and by Mr. Zuma, who never repudiated or disagreed with that, and of course by Mr. Zuma's subsequent conduct. Stalingrad wasn't invented in this case by the media. It was invented by Mr. Zuma's counsel, speaking to the media, saying we're going to follow a Stalingrad strategy. So that's the end of that point, if it has any relevance at all. Then, fourthly, I never said that the Criminal Procedure Act can't be reconciled with the Constitution. Of course it can be reconciled with the Constitution, and it has to be. What I said was that this couldn't have been an act enacted to give effect to the rights in the Constitution, because the Constitution didn't exist at the time. But nothing really matters and turns on that. I repeat what I've said before in that regard, that we are still waiting for Mr. Zuma's explanation, or our learned friend's explanation, of which is the right conferred by the Constitution, which Mr. Downer is trying to enforce in this court. If I didn't tell your lordships and your ladyships that, because he can't. And you're also waiting for them to tell us in what manner Section 14 of the Superior Courts Act, or for that matter the CPA, gives effect to that constitutional right, because Section 14 is just about how many judges sit in which courts. So the subsidiary argument is dead from the outset, because the requirements, the elements of the subsidiarity defense don't exist, or the subsidiarity principle. And fourthly, or finally, I think this is fifth, yes, fifthly and finally, I just want to refer the court to what was said in the full bench decision in the second Ramaphosa case, the Part B case, to which Her Ladyship Justice Henriques referred. This is what the court said at paragraph 67. I think it may be the passage to which she had in mind. Paragraph 67, the Ramaphosa second full bench said the following, quote, "For different reasons set out below, this court finds that the finding on jurisdiction by the full court in Part A was not wrongly made." It says it in terms. It says the court did have jurisdiction, and it says we do have jurisdiction. The finding of Justice Sutherland on behalf of the full bench was not wrongly made. So why my learned friend is so keen to say that the second full bench somehow overruled purported to overrule what Justice Sutherland said on behalf of the full bench, we don't know. My lord and my ladies, that's all I have to say, unless there's something which maybe would like to address to me.
Yes, Mr. Governor, before you sit down, in light of what is said in Kula, can you address the court on the relief that Mr. Downer Onus seeks in paragraph 3 of the notice of motion.
Can I just get there?
Yes, the ancillary orders that he seeks, should this court
Yes. These are ancillary to the 3.1 is the order which.
Yes, I apologize to my learned friend. I just wanted to say that, well, two things. One is that on the points in limine, of course, I'll have a right of reply. But the point about this so-called ancillary relief, I did not address it because
You did, Mr. Mpofu. You referred us in particular to paragraphs 20 onwards of your judgment.
No. I did. Can I finish what I'm saying? I did not address the question of the suspension order, which is the so-called ancillary relief, because Mr. Badlander Senior did not address it in chief. So I assumed that it's not being pursued.
Suffice it
But,
for
yeah.
purposes of proceeding, I'm still talking to you, if you don't mind,
Oh, sorry.
that we are of the view that you did
Oh.
address us on it.
Okay.
So, my Lord, if one reads the orders, one has to start with paragraph 2, which is that the operation of the orders made by this court in paragraphs B1 and B2 remain in force, and any such orders are not suspended pending the final determination of any application for leave to appeal or any appeals. Of course, that has to be subject to any appeal against this court's order to the SCA. We accept that. Section.
That is section 18. You're concerned about
Yes.
paragraph 3 in light of your judgment.
and
Well-
the submissions made by Mr. Mpofu with that regard.
Well, the paragraph 3 is consequential. Paragraph 3.1 is, for the duration of this order, the first respondent's private prosecution of the applicant is suspended. It seems to me that's purely corollary, unless I'm missing something. I think I may not be understanding the court's question.
I'm going to deal with it in due course.
Oh, you're going to. My learned friend for Ms. Maughan understands the point better than I do, and he says he's going to deal with it. So perhaps I can leave it to him and he will.
Maybe another bill.
Well, this is going to be a very expensive outing.
Thank you, Mr.
Thank you.
Thank you, my lord and my ladies. My lord and my ladies, the issues really have narrowed quite considerably when you remove the irrelevances. And so I'm going to focus on the points that I raised in chief. The exceptional circumstances, the harm to Ms. Maughan, the lack of harm to Mr. Zuma, and then a word on urgency. But before I get there, I need to deal with two issues. The one is why we're here, and the second is the point that's just been raised about Knoop. Now, why are we here? We are here because of two letters, which I referred to and which haven't been addressed, and which are the complete answer to my learned friend's points about lack of urgency and everything else. If I could ask the court to have regard to page 89 of the papers, that's the Maughan papers, and the court will see there at page 89, FA3, that is the letter that was written by my attorneys. And it says, we take a note of the J.G. Zuma Foundation has posted a tweet saying your client intends to appeal the judgment. If this is incorrect, please, and your client does not intend to appeal, please advise us urgently. Absent that, we will assume your client does indeed intend to seek leave to appeal. And here comes the important part. Assuming for the moment that your client does intend to seek leave to appeal, we request that 1, unless and until the judgment is set aside by any court of appeal, your client agrees that he will not take any further steps against Ms. Maughan pursuant to the summons that was set aside by the High Court. And 2, unless and until the judgment is set aside by any court of appeal, your client agrees that Ms. Maughan will not be required to attend court in the private prosecution pursuant to the summons that has been set aside, whether on 4 August or any other date. If your client agrees to what we've outlined, we propose that the parties address joint correspondence to the Judge President to request directives embodying the agreement between the parties. We believe that the aforegoing is a proposal that will limit further wasted legal costs and avoid burdening the resources of the High Court with pointless appearances that must necessarily result in postponements. It will also prevent the substantial prejudice to Ms. Maughan and cause no prejudice to your client, who will be entitled to pursue the private prosecution if the judgment of the full bench is eventually overturned. We await your answer. The answer is over the page. It is 91. We refer to your letter and the similar letter from the NPA. So there was a similar letter from the NPA. both making inquiries about the intention to appeal. Please be advised we've now received firm instructions to lodge an application for leave to appeal, which you will receive shortly. Now, if that letter had been responded to appropriately, we wouldn't have been here today. What would have instead happened is a joint letter to the Judge President, which would have said, the parties have agreed that the criminal proceedings can't go on in the absence of this. Please could we have directives? And the JP would no doubt have said, I've spoken to the criminal judge, you still need to appear, or I've spoken to the criminal judge, you don't need to appear, I'm issuing a directive. That is the reason we are here today. That's the reason. And so for my learned friend now to stand up and say, no, but when we get there on the 4th of August, maybe it'll postpone sine die. Well, I notice that he's never, ever undertaken that is what he will seek. It's always left open. It's a short adjournment, a long adjournment, a sine die. You're never told. You're told 5 to 6 months. Well, that will not be enough, because 5 to 6 months will not cover the application to you for leave to appeal, and if you refuse, the petition to the SCA for leave to appeal, and if they refuse, the petition to the Concourt. And what is going on here, as we've said, is an attempt to engage in the maximum embarrassment of Ms. Maughan. That's what's going on here. Because if that was not the purpose, any sensible litigant would have responded to this very careful and non-prejudicial letter to saying, fine, we agree. So that's why we're here. And that's what's going on. The second point is about the Knoop order. Now let me begin first with Ms. Maughan's motus of motion, and then deal with Mr. Downer's, just so that we can put that to bed. Let me start with what we accept. We accept that if a Section 18.4, if this court is with us and makes a Section 18.3 order, and if Mr. Zuma appeals in terms of Section 18.4, we accept that that will suspend the operation of this court's 18.3 order. And we accept that this court is not at liberty to prevent that happening, because Knoop says that it's not. Now, in our notice of motion, there was no ambiguity about that at all. Just get the zoom on. In our notice of motion, what we say is that we say, 2, the operation of the order of the full bench shall not be suspended pending the final determination of any applications for leave to appeal or appeals against the order. So it's an 18.3 order saying if they appeal against the main order, it's not suspended. But if they appeal against this order, it will be suspended under 18.4. So I don't think there's any ambiguity there. Yeah. And I understand that. And I think as I understand it, and I think that's where the confusion arises, as we understand it, paragraphs 2 and 3 are part of the same order. We accept that 3 flows, that's certainly the way I read it, is that 3 flows from 2, and that the reference to any application for leave to appeal or any appeals is against the main order. And I've checked with my learned friend for Mr. Downer, and we all agree, as, can I say, through gritted teeth, and as unfortunate as it may be, we accept that if there is an 18.4 appeal, that will suspend the 18.3 order and the consequential relief. That's correct.
I confirm that.
Thank you.
So, once that is so, and once we've cleared those 2 matters out of the way, what is left? Well, on exceptional circumstances, which is the first of the 3 requirements, you've heard nothing of substance. Nothing at all. As to why this case is not exceptional, we've made detailed submissions about it, and it's plainly exceptional. So the first box is ticked. On the question of harm to Ms. Maughan, I addressed a detailed submission to you, and you've heard one answer and one answer only. And the answer goes like this. The answer goes, the harm will flow no matter what order this court gives. So the argument is, if this court doesn't give an 18.3 order, then Ms. Maughan will have to appear, and that will have the harms. If this court does give an 18.3 order, then Mr. Zuma will inevitably appeal in terms of 18.4, and so Ms. Maughan will have to appear anyway, and the harm will flow. That is the argument. That is the only argument that you've heard. Now, that argument is problematic for 2 reasons. Firstly, I say again, and there's been no answer to it, it is contemptuous. I made that submission twice in chief, it was not answered, and I persist in it. It is contemptuous for a litigant to adopt that stance. But secondly, it is irrelevant, because this court has to judge the case on the facts before it. And on the facts before it, as I said in chief, there are 2 certainties. One is that absent an 18.3 order, Ms. Maughan will have to appear. The second is if an 18.3 order comes, then as a matter of law, the criminal proceedings are over and there will be no appearance by Mr. Zuma, Ms. Maughan, or anybody else on the 4th of August. None of that has been gainsaid, except to say, no, but don't worry, we're going to appeal anyway. Now, that is irrelevant for purposes of determining the harm to Ms. Maughan. So the 4 categories of harm which I identified in detail in our heads and in my argument must be accepted as having been established. We come to so the second box is ticked. We come to the third requirement, the harm to Mr. Zuma. What have you heard about the harm to Mr. Zuma? Well, what you've heard, and I wrote this down, is that our learned friend submits, no one in their right mind could suggest that the matter will proceed on the merits on the 4th of August. Well, precisely. What that demonstrates is that there is no harm caused by granting a Section 18.3 order. Because if there is a Section 18.3 order, the matter will not proceed on the merits on the 4th of August, because nothing will proceed on the 4th of August. And if there's no Section 18.3 order, the matter will not proceed on the merits on the 4th of August anyway, because that is what you are told. So what is the prejudice to Mr. Zuma of the granting of the 18.3 order? I truly, and I say this with great respect, I have no idea. My learned friend's little stage whisper, which he's so fond of, is Section 11. But I've made that point already, and it hasn't been answered. If the criminal proceedings are set aside pursuant to an 18.3 order, there is no criminal proceeding pending, and so there is no appearance in terms of Section 11 or otherwise, and so there's no risk of it being dismissed. And I've made the point, I think 3 times, that if at the end of the day, in some fanciful world, the appeal succeeds, everything will resume from that point. And you can make a note of it in the judgment, you can write it down on instruction from Ms. Maughan that that is Ms. Maughan's position. And so if Ms. Maughan were to ever adopt the stance, well, you missed that date after an 18.3 order which bound that, if there's an 18.3 order, which means that that date doesn't occur, and Mr. Zuma then doesn't arrive because there is no date to occur, we will not take the point for 2 reasons. A, because I'm telling you that we won't, and secondly, because it would be the worst point imaginable. So with respect, the Section 11 point is a phantom, and it's a desperate attempt to find some technical basis to get Ms. Maughan into court on the 4th of August. And I say again, that is what's actually going on here. All of these technicalities are just an effort to scrounge at least one more appearance, and hopefully many more from Mr. Zuma's point of view, out of Ms. Maughan in the dock. So the third box, is there any harm to Mr. Zuma? None at all. Certainly not irreparable, but in fact none at all. So where are we? We go back to the 3 requirements in the statute and that Knoop in paragraph 45 laid down. Is this an exceptional case? Unquestionably. Is there harm to Ms. Maughan absent an 18.3 order? Unquestionably. And is there harm to Mr. Zuma if an 18.3 order is granted? None at all. Now I accept that the court retains a discretion after that, because that is what Knoop paragraph 49 tells us. And I accept that on the authority of AfriForum and the other cases, that prospects of success might be relevant to that. The court expresses some doubt about how it fits in, but for present purposes, we don't shy away from it. What I tell you is that the case that is made out on those first 3 grounds is so utterly overwhelming. There's no possible basis for this court to say, well, the prospects of success tip the discretion against. Because the prospects of success of the appeal, and I stand by what I said, are hopeless. But let me assume that you're against me. Let me assume that you've had some conversion and that you think that, in fact, the judgment may well be wrong. It's a 50-50. That would still not tip the balance. Because what you would be faced with then is a 50-50 prospect of success, but with overwhelming harm to Ms. Maughan if you don't grant the 18.3 order, and no harm to Mr. Zuma if you do. Even if you assume it's a 50-50 case on appeal, and let me be clear again, it is nothing like a 50-50 case. But even if you assume it's a 50-50 case, there is no basis for you to exercise your discretion against granting this order. On the contrary, everything in this case cries out for the discretion to be exercised in favour of Ms. Maughan and for that order to be granted. So I will not detain you with more arguments about prospects of success. And it's notable that my learned friend spends so long on that, and it's revealing that he has no answer on the 3 fundamental requirements. We've addressed prospects of success in our heads in considerable detail. It's at paragraphs 19 to 32, and there's really nothing to add to that. Lastly, on the question of urgency, my learned friend again takes the point of urgency, but with respect, he hasn't actually addressed the argument. The argument he makes is wrong for 3 reasons. Firstly, because his 4th of August argument is that there's no 4th of August appearance, or there will always be a 4th of August appearance, because of his own client's deliberately contemptuous conduct. Well, I've explained why that can't weigh with the court, and so that point is bad. But secondly, this case has never been about only the 4th of August. The 4th of August is the first time the problem will occur. But you are not told what Mr. Zuma is going to ask for on the 4th of August. You're not told how long a postponement. You have no idea with respect whether it's not going to be told, well, now actually we want the trial to commence in a week's time or a month's time. You simply do not know. And if there was truly going to be an attempt to prevent urgent relief, you would have been expected to be told that on affidavit by Mr. Zuma, not from the bar in statements which appear deliberately couched to leave all sorts of rooms for argument on the 4th of August. And thirdly, even leaving all of that aside, we've drawn your attention to the Labour Court judgment in Trendy Greenies that says these matters are inherently urgent. There's no answer to that. Well, why are we still debating urgency in those circumstances? So when we step back, we submit that these cases are often difficult, the 18.3 cases. This case is not difficult. This is a case which unquestionably cries out for an 18.3 order. And the fact that we've had to come here, despite that exchange of letters, demonstrates that this is a case which is an abuse, and we persist in seeking the attorney-client costs. If you'll just give me one moment. My lord and my ladies, those are our submissions, unless there are any questions.
Thank you, counsel. We will endeavour to hand out the judgment as soon as possible, or if possible, soon. The court will adjourn.
Yeah. This is a vertical
I remember your skepticism.
Was I?
Your skepticism in the initial conversation, like, should we bring it or not?
Oh, no, I do remember. I think Janice had to persuade me.
Okay.
Enjoy.
Oh, yes, yes. Steve, would you take